Welcome to the Deep Dive. Today we're tackling something quite specific, but really crucial in Philippine criminal law. We're looking at habitualidad, also known as reiteration. It's an aggravating circumstance under Article 14, Paragraph 10 of the Revised Penal Code.
That's right. And our mission really is to get under the skin of why this type of repeat offending is treated, well, more severely. The thinking behind it is, once someone's been punished, they go out, they commit another crime. The law sees that as showing a greater perversity, a stronger tendency towards crime.
Which justifies a tougher penalty. Okay, so let's unpack this. The really key thing for you, the listener, to grab onto right away is that this isn't just about being a repeat offender in general. There's a very specific high threshold involved. It's all about prior punishment.
Exactly. It's not just having a record. For habitualidad to actually stick, three things absolutely have to be present. One, the person has to be on trial right now for an offense. That's the active prosecution part.
Yeah.
Two, they need to have a specific history of prior punishment. We'll get into what that means. And three, they have to actually be convicted of this new crime they're on trial for.
Right, but let's focus on number two, that prior punishment history. That's the tricky part, isn't it? You said it's not just about getting arrested before or even getting convicted. So what is the critical thing? What proves this perversity the law talks about?
The law uses the phrase, has been previously punished. And the Supreme Court, in cases like People v. Abella, has made it crystal clear. This means the actual completion of the sentence, not just a final judgment saying they're guilty. They must have served the penalty, fully served it.
Wow, okay, so just getting found guilty isn't enough proof for the court. They need proof the person actually did the time. I remember reading about a case, People v. Villapando from 1989. This guy had multiple prior convictions, right? Theft, physical injuries, stuff like that. But the court didn't apply habitualidad. Why not?
Exactly that reason. The prosecution showed the convictions, sure. But the records didn't prove that Villapando had actually served his sentences for those earlier crimes. It just wasn't there in the paperwork. Which really underscores how vital it is, maybe for the defense, to check if that proof of served time actually exists. It's a high bar.
Definitely a high bar. Okay, so we've established you need proof of time served. What about the type of crime they served time for previously? Does, say, serving time for theft count if they're now up for homicide?
Yes, it potentially can. Habitualidad can apply based on the prior crime statutory penalty in two main ways. First, if the penalty for that prior crime, according to the law itself, was equal to or even greater than the penalty for the current crime they're facing. So maybe they served time for homicide years ago and now they're convicted of falsification, which is a serious form of forgery. That could count.
Okay, equal or greater statutory penalty. What's the second way?
The second way is if they serve sentence for two or more prior crimes, even if those crimes carried lighter penalties than the current one. Like maybe they serve time for estafa, that's fraud, and also for theft, and now they're convicted of homicide. Those two lighter ones can add up for habitualidad.
And the key point there is the statutory penalty, right? Not necessarily the actual sentence the judge handed down back then.
Precisely. It's about how serious the law considers the offense to be, not the specific sentence imposed in that particular past case.
Got it. That's a really important distinction. So this brings us to the bigger picture. People often mix up habitualidad with recidivism. Can we quickly clear that up?
Sure. The big difference often lies in the proof needed and the scope. For recidivism, you mainly need to show a final conviction. And crucially, the prior crime and the new crime must fall under the same title in the Revised Penal Code. Like both crimes against property or both crimes against persons.
Right, same category.
But habitualidad, as we've been saying, needs that strict proof of sentence served. However, it's more flexible on the types of crimes. They don't need to be related or in the same title.
Okay, that's clearer. And there are other related concepts too, aren't there? Like habitual delinquency and quasi-recidivism. Just briefly.
Yeah, those are distinct aggravating circumstances too. Habitual delinquency is very specific. It's about committing certain crimes like theft, robbery, estafa, or serious physical injuries for the third time or more within a 10-year period. It carries an additional penalty on top. And quasi-recidivism is when someone commits any felony while they're actually serving a sentence in prison. That's considered particularly brazen.
So different rules, different triggers. But back to habitualidad. Is there any leeway? Any situation where a court won't hesitate to apply it even if the technical rules are met.
Well, there's commentary, like from Vallada, suggesting courts might show some restraint in very specific situations. Say, if applying habitualidad would automatically trigger a really severe penalty, maybe even the death penalty back when it was applicable, based only on prior convictions for crimes against property and not against people. There might be a sense that it's disproportionate, a sort of fairness check.
Interesting. A check for fairness even within the rules. So wrapping this up, the absolute key takeaway, especially if you're involved in the legal field, seems to be
Meticulous record checking. Don't just look at prior convictions. You have to verify if the sentence was actually provably served. That's often the make or break point for the prosecution and the key angle for the defense.
that requirement for documented proof of serve time, it's the linchpin. Okay, so here's something for you to think about after we finish. Does this strict requirement of proving actual sentence served not just conviction strike the right balance? Does it properly weigh the goal of punishing persistent criminality against the fact that some repeat offenders might be, consistently committing relatively minor nonviolent offenses? Where's the line?
Yeah, it's a good question. Does the focus on service completion adequately capture perversity, or does it sometimes miss the mark depending on the nature of the repeated crimes? Something to definitely mull over.